Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. And ladies and gentlemen, for this lecture, we'll provide another installation into our Anti-Federalist Papers series going on number 45. So if you haven't gone back and watched 1 through 44, I would highly encourage you to do so, because understanding the Anti-Federalist Papers, in addition to the Federalist Papers, will provide you a very well-rounded and advantageous understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. We're going on to number 45, as I said. There are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both formats. Got to untie my tongue real quick, just in case you can't access one or the other. And if you haven't done so already, go ahead and get a copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 45 is titled Powers of National Government Dangerous to State Governments, New York as an Example. This one's going to be critically important. Written by Mr. Robert Yates, and if you're not familiar with Mr. Robert Yates, he was actually at the Philadelphia Convention and recorded what was said during the debates. A very fascinating read that we will absolutely be going over in a future lecture, just not at this time. I think there are practical matters and, of course, historical matters that will be more to your benefit than Mr. Yates's work. But if you have time and you have the ambition, go ahead and look up Robert Yates's journals on the Philadelphia Convention. Very interesting read. Anyway, a delegate to the 1787 convention from New York left on July 10th, 1787. He became an anti-federalist leader. Under the nom de plume Sidney, he wrote in the New York Daily Patriotic Register June 13th and 14th, 1788. So he says this: to the citizens of the state of New York, this one's going to be so incredibly important. Get your highlighter ready. To the citizens of the state of New York, we may end up not even highlighting anything, because this one's going to be virtually everything would be highlighted. Although a variety of objections to the proposed new Constitution for the government of the United States have been laid before the public by men of the best abilities, I am led to believe that representing it in a point of view which has escaped their observation may be of use, that is, by comparing it with the Constitution of the state of New York. If you remember from the Federalist Papers, if you haven't watched that series, please go do so. Hamilton actually referred to the state of New York as an example of why the U.S. ought to adopt the U.S. Constitution. Let's see how Mr. Yates contrasts that by saying, actually, no, New York is a reason why it shouldn't be ratified. The U.S. Constitution, that is. The following contrast is therefore submitted to the public to show in what instances the powers of the state government will be either totally or partially absorbed, and enable us to determine whether the remaining powers will, from those kind of pillars, be capable of supporting the mutilated fabric of a government which even the advocates for the new Constitution admit excels, quote, the boasted models of Greece or Rome and those of all other nations, and having precisely marked out the power of the government and the rights of the people. I think that was Hamilton. That sounds very familiar. It may be proper to premise that the pressure of necessity and distress, and not corruption, had a principal tendency to induce the adoption of the state constitutions in the existing confederation. That power was even then vested in the rulers with the greatest caution, and that as from every circumstance we have reason to infer, that the due Constitution does not originate from a pure source. We ought deliberately to trace the extent and tendency of the trust we are about to repose, under the conviction that a reassumption of that trust will at least be difficult, if not impracticable. You got a little confused about what he's saying there. Is even if we want to go ahead and trust these people with this new government, let's remember that if we ever want to take that trust back, it's virtually impossible. So let's talk about this from that perspective. If we take a retrospective view of the measures of Congress, we can scarcely entertain a doubt but that a plan has long since been framed to subvert the Confederation, that plan has been matured with the most preserving industry and unremitted attention, and that the objects expressed in the preamble to the Constitution, that is, quote, to promote the general welfare and secure the blessings of liberties to ourselves and our posterity, were merely the ostensible and not the real reasons of its framers. Kind of bone-chilling, huh? The state governments are considered in the new Constitution as mere dependencies, existing solely by its toleration and possessing powers of which they may be deprived whenever the general government is disposed so to do. If then the powers of the state governments are to be totally absorbed, in which all agree, and only differ as to the mode, whether it will be effected by a rapid progression or by a certain but slower operations, what is to limit the oppression of the general government? Where are the rights which are declared to be incapable of violation, and what security have people against the wanton oppression of unprincipled governors? No constitutional redress is pointed out, and no express declaration is contained in it to limit the boundaries of their rulers. Beside which the mode and period of their being elected tends to take away their responsibility to the people over whom they may, by the power of the purse and the sword, domineer at discretion. Nor is there a power on the earth to tell them, "What dost thou?" or "Why dost thou so?" I shall now proceed to compare the Constitution of the State of New York with the proposed federal government, distinguishing the paragraphs in the former which are rendered nugatory by the latter, those which are in a great measure innervated, and such as are in the discretion of the general government to permit or not. First and 37. The first, quote, ordains, determines, and declares that no authority shall on any pretense whatever be exercised over the people or the members of this state, but such as shall be derived from and granted by them. The 37th, quote, that no purchases or contracts for the sale of lands with or of the Indians within the limits of this state shall be binding on the Indians or deemed valid unless made under the authority and with the consent of a legislature of this state. What have we reasonably to expect will be their conduct, the new national government, when possessed of the powers, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes, when they are armed with legislative, executive, and judicial powers, and their laws the supreme laws of the land? And when the states are prohibited without the consent of Congress to lay any, quote, imposts or duties on imports, and if they do, they shall be for the use of the Treasury of the United States, and all such laws subject to the revision and control of Congress. It is evident that this state, by adopting the new government, will innervate their legislative rights and totally surrender into the hands of Congress the management and regulation of the Indian trade to an improper government, and the traders to be fleeced by iniquitous impositions operating at one and the same time as a monopoly and a poll tax. The second provides, quote, that the supreme legislative power within the state shall be vested in two separate and distinct bodies of men, the one to be called the Assembly, and the other to be called the Senate of the State of New York, who together shall form the legislature. The third provides against laws that may be hastily and inadvertently passed, inconsistent with the spirit of the Constitution and the public good, and that, quote, the governor, the chancellor, and judges of the Supreme Court shall revise all bills about to be passed into laws by the legislature. The ninth provides, quote, that the Assembly shall be the judge of their own members and enjoy the same privileges and proceed in doing business in like manner as the Assembly of the Colony of New York of right formerly did. The 12th provides, quote, that the Senate shall in like manner be judges of their own members, etc. The 31st describes even the style of laws, that the style of alt laws shall be as follows, quote, be it enacted by the people of the State of New York represented in Senate and Assembly, and that all writs and proceedings shall run in the name of the people of the State of New York, and tested in the name of the Chancellor or the Chief Judge from whence they shall issue. The powers vested in the legislature of the state by these paragraphs will be weakened, for the proposed new government declares that, quote, all legislative powers therein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives, and it further prescribes that, quote, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Those who are full of faith suppose that the words, quote, in pursuance thereof, are restrictive. But if they reflect a moment and take into consideration the comprehensive expressions of the instrument, they will find that their restrictive construction is unavailing. No, that can't be so. They will always be men of honor and women of honor in government. Therefore, that will be restrictive. Thank goodness that's true. Construction is unavailing, and this is evidenced by first article, 8th section, where this government has a power, quote, to lay and collect all taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, and also, quote, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers vested by this Constitution in the government of the United States, or in any department or office thereof. To conclude my observation on this head, it appears to me as impossible that these powers in the state constitution and those in the general government can exist and operate together, as it would be for a man to serve two masters whose interests clash and secure the approbation of both. Can there at the same time and place be and operate two supreme legislatures, executives, and judicials? Will a, quote, guarantee of a republican form of government to every state in the Union, that's Article 4, Section 4, be of any avail or secure the establishment and retention of any state rights? Of state rights. He didn't say any. Of state rights. If this guarantee had remained, as it was first reported by the committee of the whole House, to it, quote, that a republican constitution and its existing laws ought to be guaranteed to each state by the United States, it would have been substantial. But the changing the word constitution into the word form bears no favorable appearance. Exactly. I figured, I said get the highlighter prepared, but all of this is worth highlighting. So just save your ink, or whatever compound highlighting fluid is made of. 13, 35, and 41. By the 13th paragraph, quote, no member of the state shall be disenfranchised or deprived of any of the rights or privileges secured to the subjects of the state by this Constitution, unless by the law of the land or judgment of its peers. The 35th adopts, under certain exceptions and modifications, the common law of England, the statute law of England and Great Britain, and the acts of the legislature of the colony, which together formed a law on the 19th of April, 1775. The 41st provides, quote, that the trial by jury remain inviolate forever. No suspension of habeas corpus. That no acts of attainder shall be passed by the legislature of this state for crimes other than those committed by before the termination of the present war, and that the legislature shall at no time hereafter institute any new courts but such as shall proceed according to the course of the common law. There can be no doubt that if the new government be adopted in all its latitude, every one of these paragraphs will become a dead letter. Nor will it solve any difficulties if the United States guarantee, quote, to every state in the Union a republican form of government, again Article 4, Section 4, we may be allowed the form and not the substance, and that it was so intended will appear from the changing the word constitution to the word form and the omission of the words and its existing laws. And I do not even think it uncharitable to suppose that it was designedly done. But whether it was so or not, by leaving out these words, the jurisprudence of each state is left to the mercy of the new government. Precisely. 17, 18, 19, 20, 21, 27, and 40. The 17th orders, quote, that the supreme executive power and authority of the state shall be vested in a governor. By the 18th, he is commander-in-chief of the militia and admiral of the navy of the state, may grant pardons to all persons convicted of crimes. He may suspend the execution of the sentence in treason or murder. By the 19th paragraph, he is to see that the laws and resolutions of the legislature be faithfully executed. The 20th and 21st paragraphs give the lieutenant governor, on the death, resignation, removal from office, or impeachment of the governor, all the powers of governor. By the 20th, he, the governor, is president of the council of appointment and has a casting vote in the commissioning of all officers. The 40th paragraph orders that the militia at all times, both in peace and war, shall be armed and disciplined and kept in readiness. In what manner the Quakers shall be excused, and that a magazine of warlike stores be forever kept at the expense of the state, and by act of the legislature established, maintained, and continued in every county in the state. Whoever considers the following powers vested in the national government, and compares them with the above, must readily perceive they are either all innervated, or annihilated. By the first article, section 8, 8th section, 15th, 16th, and 17th clauses, Congress will be empowered to call forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, to provide for organizing, arming, and disciplining the militia, for the governing such part of them as may be employed in the service of the United States, and for the erection of forts, magazines, etc. And by the second article, second section, the President shall be Commander-in-Chief, this is a quote, the President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into actual service of the United States, except in cases of impeachment. And by the sixth article, quote, the members of the several state legislatures and all the executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support the Constitution. Can this oath be taken by those who have already taken one under the Constitution of this state? From these powers lodged in Congress and the powers vested in the states, it is clear that there must be a government within a government. Two legislative, executive, and judicial powers. The power of raising an army in time of peace and to command the militia will give the President ample means to enforce the supreme laws of the land. 42. This paragraph provides, quote, that it shall be in the discretion of the legislature to naturalize all such persons and in such manner as they shall think proper. The first article, 8th section, 4th clause, give to the new government power to establish a uniform rule of naturalization, and by the 4th article, second section, quote, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states, whereby the clause is rendered entirely nugatory. From this contrast, it appears that the general government, when completely organized, will absorb all those powers of the state which the framers of its constitution had declared should be only exercised by the representatives of the people of the state. That the burdens and expense of supporting a state establishment will be perpetuated, but its operations to ensure or contribute to any essential measures promotive of the happiness of the people may be totally prostrated. The general government arrogating to itself the right of interfering in the most minute objects of internal police and the most trifling domestic concerns of every state by possessing a power of passing laws, quote, to provide for the general welfare of the United States, which may affect life, liberty, and property in every modification they may think expedient, unchecked by cautionary reservations and unrestrained by a declaration of any of those rights which the wisdom and prudence of America in the year 1776 held ought to be at all events protected from violation. That whole paragraph is worth highlighting. This whole paper is worth highlighting, which is why, my apologies, you can go ahead and cap away your highlighter. Do go ahead, if you have a sticky note, if you have a bookmark, anything like that, highlight this paper. This one is so incredibly important because it comes directly from a delegate at the Philadelphia Convention. This gentleman did not vote to ratify the U.S. Constitution. That means the U.S. Constitution failed the unanimous agreement between the states' requirement of the Articles of Confederation, which means the U.S. Constitution was never ratified, it was implemented, it was imposed, which means it is not a binding, it is not a standing, it is not a legitimate governing document. Therefore, it cannot be obeyed, it cannot be imposed, it cannot be enforced. And according to Madison, the father of the U.S. Constitution, you, as a citizen of your state, are duty-bound, required to not conform, to uphold the only truly governing document over the union of these states, which would be the Articles of the Confederation. Again, this isn't insurrection talk, this isn't sedition talk, this isn't treason talk. This is Father of the U.S. Constitution talk. This is exactly verbatim what he said to do. So if you're going to call me a traitor, if you're going to label the Calhoun School of Law a seditious institution or treasonous or an insurrectionist, then you're going to have to do the very same thing for the very man, or to the very man who wrote this supposed document that governs you, that you believe governs you. Are you willing to do that? Are you willing to go to that extent? Let's go ahead and finish up this Anti-Federalist paper. So Mr. Yates says, in a word, the new Constitution will prove finally to dissolve all the power of the several state legislatures and destroy the rights and liberties of the people, for the power of the first will be all in all, and of the latter a mere shadow and form without substance, and if adopted, we may, in imitation of the Carthaginians, say, Delenda vit America. Signed, Sydney. All right. If you have any questions about what was said in number 45, maybe questions about what was said in the preceding Anti-Federalist papers, or if there's a topic you'd like me to cover in a future lecture, go ahead and post them down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that so many bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.